So thank you for having me, and there was a good segue to talk about the 12-year-old that is potentially left at home with their siblings and hoping nobody will find out, and of course if they do, someone's going to call DHS, and assuming that what we heard about in the other presentation about, and what Leslie talked about in terms of the network of friends and family support that try to step in and take care of these kids, when that's not there and that doesn't happen or that falls apart, then the children will likely end up in foster care and wards of the court. It's interesting because the focus of the first two speakers' comments were really around ICE cases and raids and what happens in the federal system in terms of immigration. I represent DHS Child Welfare, and I should say that my comments today are not necessarily those of Mr. Kroger, Aaron Kelly Seal, Bruce Goldberg, or any of the other state aficionados who are above me, and I certainly can't speak on behalf of the federal government or ICE, who are not my clients. But I would say that the cases that I've had contact with as we've been maneuvering the minefield that is immigration law within state child welfare services in the last 2 years, a small percentage of those cases involve ICE immigration holds. Some do. Most of the cases, however, where we see the impacts of immigration law in our child welfare cases are parents who come into the country, most of the time from Mexico. We also have kids from other countries in South America and Central America. We've also had kids from Europe, Russia, the Ukraine, a lot of Eastern European countries, and Canada, where there are immigration implications in terms of child welfare planning. Our world is becoming much more global. People are much more transient in their, it used to be that somebody lived in a town forever. It's my plan, because I live in McMinnville and it's the nicest place in the world. But that's not the reality for most people today, and even country to country. So we're having immigration impact child welfare work a lot more. But most of the cases that we see where we have really tough immigration cases are parents who have come in, majority from Mexico, and they've brought a child with them, and they've entered without inspection when they've entered the United States. So they've crossed the border without a visa, and they've brought their child with them into America. And then once they get into the USA, child welfare becomes involved, in the same way that child welfare becomes involved if you're a U.S. citizen, because the parents are involved in drugs, abuse, neglect, criminal activity, and all of those circumstances that lead to DHS involvement in someone's life. And yes, we do have a fair number of cases where the involvement is a result of criminal activity that leads to incarceration that may at some point also lead to an ICE hold, an immigration action. But I'd say the majority of the cases we've had don't involve a deportation of a parent or any type of formalized deportation proceeding. Many of them are people who are held in state custody, even though they are undocumented folks here. They're not deported, but they're serving a sentence, which may lead to deportation at the completion of their sentence. But regardless of their immigration status, child welfare would be involved in that case because of the inability of the parents to meet the children's needs. So prior to April of 2008, and this is why suddenly, as a child welfare lawyer for the last 9 years, I never thought I would know anything about immigration law. And one of my best friends from law school is an immigration lawyer, and she talks about her cases, and I'm like, yeah, whatever, doesn't affect me. Now suddenly, in the last 2 years, I've spent, 20% of my time focused on immigration issues and child welfare. And that's because prior to 2008, the Hague Convention on Protection of Children and Cooperation in Respect of Intercountry Adoption and Intercountry Adoption Act were applicable only to private adoption agencies. And in April of 2008, the amendments went through that made them applicable to state child caring agencies. So any state child welfare system is now subject to the requirements of what we lovingly refer to as the IAA and the Hague. So what does that mean? Why did they do that? It made my life a lot harder. They did it because they wanted to protect children from trafficking, and because they wanted to ensure that all policies and procedures and due diligence was given in cases of foreign adoptions. When we talk about it internally, we talk about they wanted to save families from the Madonnas of the world. Sort of the idea that some rich white person was going to go into some third world country where people had a lot less resources and find a charming child in an orphanage or a care center, and without doing due diligence around locating that child's biological family, adopt them and bring them back to their country of origin. We like to believe that us in Oregon Child Welfare aren't doing a lot of that. Unfortunately, the Madonnas of the world and the Angelina Jolies are not coming to us looking to adopt our children, and if they would like them, we have many waiting, and I'm sure they'd be thrilled. So it was a little frustrating to us, because of course we had been placing children with relatives, which is one of the policy and legislative priorities for the agency, is to place children with relatives as a first choice. So if those relatives were located, say, in Mexico, and the parents weren't a viable resource and the relatives were fit and willing to be a permanent plan, we were placing children in Mexico and working through the Mexican Child Welfare Agency and the consulate here in Portland in order to get completed home studies and process adoptions with relatives in Mexico. Well, that was put on hold. The Hague applies to outgoing and incoming adoptions. So when you're thinking about the way that international law and immigration impacts children, it's not just the kids here who are having problems around issues with their parents and achieving permanency in the United States when they're undocumented, and what does that mean for them in the future in terms of their citizenship and their ability to work and to be productive members of society and safe and secure people in the United States. But also, what about these kids that have fit and willing relatives in Mexico that they want to be reunited with when parents aren't an option? And we couldn't finalize those either. So in 2009, in 2008, April 2008, we started talking to the State Department, USCIS. What does this mean? What do we do? How do we do it? We started having some conference calls. And I should tell you that to date, the Department of Human Services at the federal level still has not implemented any plans, guidelines, or directions for state child welfare agencies and how to implement the IAA and the Hague, and it's been 2 years. So Oregon, I'm proud to say, unlike the majority of the rest of the country, said we're not going to wait around. We've got these kids in Mexico with relatives. We've got other kids here in the USA who are eligible for adoption or another permanent plan like a guardianship with a relative, and we're not just going to leave them sitting on the shelf while somebody else tries to figure this out. Also, we weren't willing to give up on these kids. So we weren't willing to say, we're just going to do permanent foster care, which I'm sure somebody has told you if you take juvenile law is a lie. There's no such thing as permanent foster care. So it's really warehousing kids, and the average teen and the average child that ages out, Leslie, correct me if I'm wrong, but I think they have like 10 placements. So that's permanent foster care for you. So we weren't willing to just say, well, we can't do it, sorry kids, come back and we'll put you in stranger foster care and move you every other year. So we said, no, we're going to try to figure it out. So we contracted with a wonderful immigration firm, Black Helter Line in Portland, and had them appointed as special AAGs to give us advice on how we navigate this minefield. We came up with what do we do for those kids that are brought into the country whose parents aren't able to be a resource, where we're going to move forward with an alternative plan like guardianship and adoption. We call those the incoming cases. And then what do we do with these kids who have who don't have a parent who can be available within a reasonable time, given that child's developmental attachment needs, but who do have fit and willing relatives that want to be a resource in a Hague nation? So first we have to determine what's a Hague nation. For the purposes of this, let's just talk about Mexico, because they are, and that's the majority of our cases. So for the incoming cases, we were able to determine that if we get, and you've heard discussion about it already, special immigrant juvenile status, which is something that, which is an application that you file, and it's an amazing process. I've got the procedures right here, and it's, I don't know how many pages. But you file an application for special immigrant juvenile status for a child who's been made a ward of the court after the juvenile court has made findings that the child cannot be returned to the parent. So this is a proceeding that really needs to happen after a permanency hearing has occurred in juvenile court, after the court has determined that return to parent is no longer a plan for the child. And so at that point, the court can make findings that the child is eligible for long-term foster care, which really...
Don't need that anymore.
Oh, right, it did change. That's right.
Oh my God.
The court has to determine that the kid's not going to go home to their parent, and also that there's been a diligent effort to find relatives to place the child with in their country of origin, and those efforts have not been successful. And there's a whole other laundry list of findings that the court has to make, most of which are not difficult for the court to make. And then you attach those findings to your application for special immigrant juvenile status, and that allows eventually for the child to receive a green card. So unlike what we heard about, you know, basically in most cases, once you've entered without inspection your host, it's very difficult to undo that without returning to Mexico and re-entering with inspection. So, but in the case of SIJS, that's not required. So that's basically a way for the child to have their status changed without having to go back to Mexico. And once they have their status changed to special immigrant juvenile status, that says this child is here lawfully. It's a path to a green card. And once the child has a green card, they can apply for a social security number. That doesn't make them a citizen, but it makes them eligible to then apply for citizenship lawfully without having to return to their country of origin. So in a case of an adoption or a guardianship case, the Department of Human Services, if they determine they want to achieve one of those permanent plans for a child, then they will approve hiring my office to work alongside Black Helterline to get SIJS status, so that once the child is in that guardianship or in that adoptive home, their guardians or adoptive parents are able to then pursue citizenship for them after they've had their status adjusted. The outgoing cases have been a lot harder. There was a moratorium on placing any children in Mexico for about a year, while the legislature enacted new laws, DHS enacted new rules. We worked very closely with DEEF, the Child Welfare Agency in Mexico, and with the consulate in Portland, the State Department, USCIS, and our SAGs to develop policies and procedures for home studies, supervision agreements, to be in compliance with Hague and the IAA. And also we realized that it was just best practice. There was a huge case in the Oregonian a couple years ago that highlighted what happened when DHS placed a child in Mexico for the purpose of adoption with a relative, and then that child was murdered. So we also understood that we weren't doing, and when I say we, I don't mean me, but my client, necessarily, but you know, they've come out publicly and said, hey, we weren't doing the best job that we should have done, partnering with child welfare agencies in Mexico around supervising children in adoptive placements with relatives, and we're going to do better, and the Hague and the IAA help us have the framework to get there. I'm happy to say I approved a case to pursue adoption for a sibling group of 3 kids. It had been a case that I had had for way too long, I think since 2005. These kids came into care. 2006, the court changed the plan from return to parent to adoption. 2007, the children were declared legally free after one parent's rights were terminated and the other parent relinquished. And just to get back onto the parent side of it, we have a lot of these cases where parents are voluntarily relinquishing their parental rights or stipulating determination of parental rights in cases where where the parent has worked with the agency to identify fit and appropriate relatives in Mexico. So you can imagine you've got a mom who's sentenced to 20 years in prison, and she says, what I want is for my children children to be raised by my mother in Mexico. And everyone's on the same page, and there's a uniform agreement, and it's the family's plan, and the agency's helping to implement it, and then we're on hold for 2 years and nothing's happened, and this mom has relinquished her rights and her kids are waiting in foster care with strangers for us to get them to grandma in Mexico, and we can't even place them there. So those are the kind of heartbreaking cases that were going on during this time. So these kids were legally free in 2007. The grandmother had a home study in Mexico that was initially approved right before the amendments came into The Hague, and then we had to go through all the hoops to get a supervision agreement and a Hague-compliant home study, which was a whole new animal, and develop the first contracts between Mexico and the United States for supervision of kids in care in Mexico to be in compliance. So those are international contracts that have to be reviewed and approved by the State Department and by the consulate, and it is quite a process, especially when it's the first time it's ever been done in the United States.
They get adopted.
Yes.
Formally.
And so in April of 2010, finally, after we had to go to court and get the court to make Hague findings, which includes that the juvenile court has to find it's in the best interest of the children to be placed in Mexico with the relative for the purpose of adoption. Now, I've had one case where the court would not make that finding because the child's attorney objected because the child's attorney thought that the young child, I think he was 2 or 3, she was 3, should stay with her current caretaker, non-related foster parents and not be placed in Mexico. And one of the controversies was she was an American citizen. You have to remember that all these kids are not necessarily citizens of other countries. The Hague applied in this case because her parents were citizens of Mexico, and the relative that we had to place her with, which is where both her mother and father wanted her mother and father both relinquished their rights, lived in Mexico. So the Hague applies even though she was born here, has a U.S. birth certificate, and is a U.S. citizen. But there's a lot of controversy around should we place a U.S. citizen in Mexico, a 3-year-old U.S. citizen, and what does that mean for her in terms of the opportunities that she's going to have, and is that what we should do, and how does that play with DHS's obligation to place children with relatives? So DHS was advocating for the grandmother in Mexico who had been selected at DHS's committee, but that's not what the child's attorney wanted, and in the end the court sided with the child's attorney and did not find that it was in her best interest to be placed in Mexico. However, my kids that I started out with in April of 2010, that sibling group of 3, this past July, right after school got out, July of 2010, they flew to Mexico and they've been with their grandmother, and they were the first children placed in Mexico since the moratorium on placement went into effect after the Hague Amendments in April of 2008. And Oregon is the first state to have developed those policies and procedures and been able to carry that out. I've held green cards in my hands that we've gotten for kids we've gotten SIJ for, so we can move forward on permanent plans for them. And these aren't only cases with 3- and 4-year-olds that we're looking to adopt. We've got 2 cases in the pipeline right now for 18-year-olds where we're looking to finalize a plan for them and a chance for them in terms of their independent living program so that they can age out of foster care with the opportunity to attend college and to have a job and be successful when DHS isn't there to be their parent. So those are just some of the interesting things I've been working on in the last couple years for DHS. So that's all. Thanks.